good that you're doing this, because I think these are good times to communicate issues which are difficult sometimes to accept on a one-to-one basis also. One thing I would say that in India, there is for some reason an averseness to making a will. And I've never understood this. So if you advise someone, have you made a will? The normal answer is, I'm not dying tomorrow. And that's a very common kind of in my view, fairly silly answer, but that's a very common answer, strangely. And this happens at various ages. Now, why should one have made a will at all? So we have in India what is called personal succession laws. So that's already recognized. So how the estate of a person who passes away, who is following the Hindu religion, the rules are set. The Muslim religion, the rules are set, etc. There's an Indian Succession Act which governs generally all succession, which is not sought under one of these special customary laws. Under the Indian Succession Act, a will is a document expressing the intention of the owner of property as to how he or she wants that property to be dealt with after he or she passes away. So will takes effect upon the death of the author. It has no value while you're alive. A lot of people sometimes say, no, you had said you leave it to me, or your earlier will said you leave it to me. That's all meaningless. So a person can keep making wills whenever they want. The ingredients are they must be of sound mind, which means that they have the ability to understand what they're doing, understand where they are, understand who they are, understand what property they have, etc. And there's a mental test that is administered by doctors to test this. And a certificate is often put with the will, which is advisable after a certain age. Because as I'm sure our friend the doctor will say, after a certain age, certain faculties do start fading and things like dementia, etc. coming. So if a will demonstrates who it is by, what property it seeks to leave, and that can be generally described. It need not be specific to specific bank accounts or specific shares. It can be even general. Who the property is being left to, including donations to charities, including to children, third parties, etc. You also normally put a provision that if the person you're leaving it to dies before you, what happens? Because it is possible the person you're leaving property to dies before you. A requirement is it should be signed by the person making the will, and there should be two witnesses. And the witnesses should not be persons who are going to inherit under the will. So two independent people, there's no mandate that it has to be a lawyer or a doctor or anything. It could be any two people. And they are supposed to say there that they have seen the person who's making the will sign, and they are witnessing the signature and effectively witnessing the signature of each other. So there's a specific clause they put, I'm signing in the presence of the testator and each other. There is a common practice to name an executor or executors who are supposed to step in and administer the property during the time that it's still in the name of the deceased and has not gone to the name of the persons who the property is being left to. But otherwise, there's nothing specified. It need not be on stamp paper. It need not be typed. It can be handwritten. It need not be registered. It need not be notarized. So many of these are misconceptions that these are required. They're not required. Often we prescribe that at least make 2 or 3 copies and put them in different places. Keep one with a trusted person. Maybe keep one in your own locker. And maybe one more, if you want to register, you can, although it's not mandatory unless you're leaving a whole bunch of property outside your family, in which case it's better to register. So fairly simple and fairly safe. After the person dies, depending upon what the property is, it may or may not require that the will is proved. Proof is done by a probate petition in a court having jurisdiction. If there's an executor or executors, they file for probate. If there are no executor or executors, you file something called letters of administration, similar, but can be done by any of the legatees. You don't need an executor for doing that. Now, one thing that commonly causes confusion, I'm going to stop after this, is that people often say the courts, Supreme Court, High Court, etc., have stated that when there's a nomination form filed with a housing society or your mutual fund or the bank account, etc., then the nominee becomes the owner of the property. That's not the case. The nominee's name is stipulated originally just for information. In housing societies, what happened was, if you did not know where the property was to go, nobody would pay the monthly bills, the maintenance bills. And everyone would say, so I don't know yet whether it's mine. And similar concepts arose in mutual funds, etc., if there was some fees we paid. So what they said is that a nominee steps in right away. The nominee's name is put on record right away, but the nominee holds it for the ultimate heirs. It's not his property by inheritance, it's his property by virtue of being a nominee. So I've tried to be as comprehensive as I can on this answer. I know it's a bit long.